Hello, everyone. This is Jerry Turbofield, and again, we're continuing the CRI-325 judicial process, and we'll be covering chapters 5 and 6 of this PowerPoint presentation. We'll go ahead and get started. In this chapter, we'll examine the purposes and the function of the grand jury and then proceed to the next step that usually follows a grand jury indictment and arraignment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. That's part of the Fifth Amendment of the Constitution. The U.S. Supreme Court has never held that this provision of the Fifth Amendment applies to the states. However, in North Carolina, we do indict people for felony level charges as a general rule. Grand juries have been a feature of American and English law for centuries. Grand juries do not reach verdicts. They find probable cause to continue the prosecution of a criminal case. Grand jury versus a regular jury, the differences between them. Grand juries have more than 12 members typically. They do not determine guilt or innocence. They're only looking to see if there is sufficient evidence here to merit that this case goes forward onto trial. They do not recommend sentences, and they meet regularly, often monthly, to discuss numerous cases. Grand jurors must be members of the jurisdiction. They cannot have been convicted of a felony, and they must be U.S. citizens. They're selected from a cross-section of the community, including various races, both sexes, and various occupations. The usual number of jurors is between 12 and 23, and again, it's depending on the jurisdiction. Typically, what I've seen in Avery and Watauga counties is about 18 normally, and sometimes there are people that weren't able to make it on that particular day due to illness or things of that nature. But typically, if everyone's there, there'll be about 18. It's typically held in a small room. There's normally a crowd of people in there because you have those 18 folks, and they're all around the edges of the room. And when you walk in as an officer, you have your file folder of the particular case that you're called in to give testimony concerning, and you simply walk into the middle of the room, and they will, of course, someone will hand you a Bible. You will take an oath on the Bible that you're going to be telling the truth. And then you move forward from that point. You discuss your case. You explain what you want to tell them about the case. This is strictly a one-sided affair. This is only the prosecution side. There is no defense attorney there. There's nobody there to defend them. And you can actually delve into opinions whenever you're talking about this. You can say, look, this person I think is guilty. They've been a criminal for many, many years. You can say things that are your opinion, and in the grand jury, all that goes. There's no judge overseeing it, as far as sitting right in the room with them at least. And there is a jury foreman, and that jury foreman tends to run the show, but typically they allow you to say what you want to say about the case. For this reason, there's always been a running joke for many years that indictments shouldn't impress anyone because you can indict a ham sandwich. And that's very, very true, because indictments are very easy to reach that standard, that probable cause standard. As a matter of fact, if you've gotten that far along in the process, there's so many stops along the way where probable cause is examined. For instance, the officers, of course, will know their level of probable cause, which is that a person probably committed this crime, better than a fair probability, better than 50% probably, if you want to look at it that way. And the officers themselves will look at it. A lot of times an officer will discuss it with his or her supervisor and say, look, what do you think about this case? Is there enough here to go ahead and charge this person? And they'll discuss it. And this just comes from experience, because obviously it's their job to prosecute people, to push this through. But at the same time, officers don't want to push through cases that aren't going to make it. If there isn't enough there to get over the various hurdles in court, then they don't want to push that up there because it's a waste of time and effort for them. So it's always been my experience that really once it gets to the point that it's beyond the indictment level, it's cleared so many hurdles the case has. There's definitely probable cause there. That's not to say the person may not win the case in court, because you've got to reach that very high standard of proof beyond a reasonable doubt. But regardless, it is difficult to get that far along in the process, and there has to be some merit to the case. Grand juries are somewhat archaic, I feel like. You're bringing in a jury of common citizens, and you're having them review these cases to make sure there's enough there to continue on in the process. And there are almost enough standards now. This was a holdover from way back, and it speaks to a time when there really wasn't any training for law enforcement, and it's one of those situations. There was much less professionalism, and now all that has changed to a great degree. So grand juries are maybe perhaps not as important in the process as they once were. However, the law says that certain things must be, certain crimes must be indicted before they can move forward. So sometimes that happens. The grand jury is devised to act as a buffer between the state and the defendant. The essential function of the grand jury is to determine that there's probable cause to believe that a crime has occurred. The government must present enough information for a prima facie case of guilt against the defendant. Prima facie is a legal term. It simply means on its face, the way that it appears to someone when it's presented. This means that the state must present a basic case to the grand jury showing that the defendant is a person who most likely committed the crime. To tell you how rare it is with grand juries to actually have them fail to send the case on up for court, it almost never happens. It is extremely rare. I've only seen maybe once that this occurred, and it was someone that really didn't know what they were doing yet, and the case had various problems, so many questions came up. So it's very, very rare that an indictment does not get passed on by the grand jury to go on up. It's extremely rare. It's almost a foregone conclusion that they'll be successfully indicted. If a grand jury votes for what's called a true bill, then the case against the defendant continues. If the grand jury votes no bill, then the case against the defendant is dismissed. In federal grand juries versus state grand juries, although grand juries are required under the federal system, that provision of the Fifth Amendment has never been made applicable to the states. In states that require grand juries, some offenses can still bypass the grand jury. Relatively minor offenses such as driving of a habitual violator, some sort of offense of that nature, it may now be presented through an information or accusation instead of an indictment, which again just probably saves time and money as far as that goes. The federal rules of criminal procedure authorize grand juries to serve a maximum of 18 months, although there are provisions that allow the grand jury to extend its time in rare instances. There can be such a thing as an immunity under a federal grand jury. When a person's been granted immunity, it means the testimony given before the grand jury cannot be used as the basis to prosecute that person. Grand juries can issue subpoenas, which is a court order requiring a person to appear and testify. Grand juries can issue subpoenas for people as well as for documents. A person who fails to abide by a grand jury subpoena is subject to finding of contempt of the grand jury and may be held in custody until he or she complies. You can quash a subpoena, which is an effort to make it go away or invalidate it. And a motion to quash is filed with the court and describes the material that's been subject to subpoena and the reason the party objects to producing these documents. Grand jury secrecy. Grand juries can carry out many of their duties in secret. Their discussions are not placed on any record, and often their identities remain secret until the indictment is unsealed or made public at the arraignment. Defendants have no right to appear before a grand jury in most jurisdictions, and in some, a defendant can request special permission to appear before the grand jurors and answer their questions. I have never heard of this happening here. I'm not saying it's impossible, but I've never seen it. The procedure before the grand jury. In some states, the prosecutor attends the grand jury meeting, questions the witnesses, and presents the evidence. In other states, the grand jury conducts its own investigation and questioning. In either situation, grand jury members always have the right to ask questions of any witness. And presenting a case to the grand jury, it's a lopsided affair, as I said earlier, and they only hear from the government's side, not the defendant. The grand jury can request anyone to appear before it to answer questions, but that does not always mean that the person will answer those questions. A witness does not lose his constitutionally guaranteed right when you're subpoenaed to appear before the grand jury. You can plead the fifth before the grand jury, which the Fifth Amendment provides that persons cannot be compelled to give evidence against themselves. This protection follows defendants into the grand jury room. If a defendant or other person is subpoenaed before the grand jury, she does not have to admit any criminal action or give any testimony that might be incriminating. The defendant can invoke the Fifth Amendment and refuse to give any answers that might implicate him or her in a crime. Invoking a privilege before the grand jury. A privilege is a legal right that protects a person from being compelled to testify about certain matters. For instance, attorney-client privilege or doctor-client privilege. There they have a legal protected right to keep private the information that's shared between them. A witness cannot be compelled to violate these privileges. There are contempt powers of a grand jury. If a witness fails to answer questions or present subpoenaed documents to the grand jury, they can request that a superior court judge hold the witnesses in contempt. If the judge agrees, the witness can be held in custody until the witness decides to cooperate. When the grand jury decides there's sufficient probable cause to believe that a crime has occurred, they can vote true bill. If the grand jury does not believe that sufficient probable cause has been established, the grand jury can vote no bill. After the grand jury's decision, and once they've made their decision, its function ceases. Once the grand jury has true billed an indictment, the case will then be ready for arraignment, and the grand jury's role has ended as far as that particular case goes. An indictment is the charging document that is used to accuse a defendant of a felony. In our jurisdiction, the district attorney's office, they produce the indictments, the form that's actually handed to the grand jury, and they will review the form briefly. They call the officer in. The officer gives his or her testimony concerning the events of the case, very briefly, and it's an extreme Cliff's Notes version, just very brief, the highlights of the case. And again, it's only the prosecution side, so they only get to hear one side of this. So it's very lopsided. It's just meant to see if there's enough to the case to actually send it on up for court. And some of what you're hearing in this presentation concerns other types of grand juries. There are investigative grand juries and things of that nature. I've not seen those in North Carolina. I primarily hear about those from some of the northeastern states I know have them, and certain mob or RICO type cases. They'll put together an investigative grand jury, and they'll continue to call in witnesses and try to determine if a charge is appropriate in a certain situation. However, here, primarily, it's the grand jury served to basically hear a case that has been slatted to go on to superior court, and it involves felony level charges and usually very serious type situations. Situations that could end with the defendant in prison, basically. The purpose of the indictment is to advise the defendant of the charges against her. An indictment, in order to be legally sufficient, must put the defendant on notice of the nature of the charges, including specific facts such as dates, places, and individuals involved in the crime. Prosecutors draft indictments and present them to the grand jury. In drafting the indictment, the prosecutors must be careful to meet all statutory obligations. These are very technical documents, and I've seen many, many times that there are mistakes on the indictment. An indictment will be handed down by the prosecutor's office. It'll go before the grand jury, and the officer will go in and testify, and everything is fine. The grand jury votes true bill. That case needs to go on to Superior Court. And then the next month, the officer gets a notice from the DA's office that, sorry, we didn't put something in there correctly. Some of the charging language is incorrect, or perhaps we even charged a slightly wrong statute. We would prefer to charge it this way. Or in certain cases, people are being charged with multiple crimes involving several incidents over a period of years. And they may have decided that we would be better charging this and this, and maybe not this one here that we've already indicted on. So you end up having to go back before the grand jury on a new indictment that changes all of that previously. I don't mean to be too confusing on that, but there have been several situations I've been involved with where the language in the indictment from the prosecutor's office was incorrectly drafted, and we had to go back and correct that. But again, it's not a problem. You just have to go back before them and present the case another time. You can possibly challenge indictments if a defendant believes the indictment's not legally sufficient. You can challenge the indictment and move to have it quashed. When you're quashing an indictment, you can say that the grand jury acts in an improper way, bringing a true bill. A court may quash or dismiss the indictment. A defendant will file a motion to quash when he or she believes that the grand jury has acted improperly. An indictment may also be quashed when it fails to allege the crime of which the defendant has been charged or some other legal deficiency. Again, these are the reasons that the district attorney a lot of times will have us re-indict people, is that they actually notice when they're combing through their documents that, hey, we didn't do this document completely correctly. They're very technical, and it's easy to make a mistake on them. So in order to withstand a robust legal challenge from the defense, they simply re-indict so that everything is corrected when it comes to court. The bill of particulars is a motion filed with the trial judge that alleges that the state's not provided the defendant with sufficient information to prepare a defense, and asks the judge to order the state to provide these additional details to the defendant. An arraignment. When a grand jury returns a true bill, the next procedural step for the accused is the arraignment. An arraignment is a court hearing at which the defendant is brought before a judge and officially informed of the charges pending against him or her. The defendant is given the opportunity of entering a plea of either not guilty or guilty. The defendant may reserve the right to file additional motions after going through the indictment and whatever discovery the state may have served on him at the arraignment. A defendant is always free to waive both formal and informal arraignment through his or her counsel or by filing a written notice waiving arraignment and filing motions about the specific issues in the case. If a defendant fails to appear for arraignment, the judge can authorize a bench warrant, and the warrant permits any law enforcement officer to arrest the defendant and place him or her in custody pending a new court date. Now we'll talk about discovery and pretrial motions. Discovery refers to the process by which both sides in a civil or criminal case exchange information. Traditionally, very little discovery was allowed in criminal cases. That is no longer the case in North Carolina. I can assure you the defense gets everything. Everything we have, the defense gets. They're allowed to have access to every document, every file footage, everything we have. Basically, the defense can have so that they can put together their defense in the case. Discovery that is normally provided by the prosecution is a witness list, scientific reports, the defendant's statements, and physical evidence. Again, in North Carolina, they get everything. State and federal prosecutors are required to give the defendant a list of the witnesses that the government intends to call during the trial. This list consists not only of the names of the witnesses, but also their addresses and phone numbers. And that's typical here, but like I said, they get everything, so that these reports and various items are just part of that package. They even get the little officer's notes that the officer scribbled to himself during the case. For instance, if the officer was talking on the phone to some witnesses, just seeing what they claim they saw on a particular evening, and the officer sitting there writing an occasional note about that, just to remind, just as a reminder, so that you can go back later and fill in the report appropriately with the information. If you're sitting there making doodles on that piece of paper, technically that piece of paper also is, because there was something written down concerning the case on it, it becomes discoverable. It becomes something that becomes a part of the case file. So you have to be very careful about what you write down in that regard. As a matter of fact, North Carolina's laws are about as stringent as they can be. It's one of the most strict in the country on discovery, for the simple reason that we have to provide every single detail that we have to the defense. It's so strict that the State Bureau of Investigation, if they have a large, for instance, a large murder that they're working and have multiple agents working on the case, they'll often have meetings in the morning to determine, okay, this agent team is going here to interview these people, and this team is going here to collect this or that evidence, or what have you. And they'll actually have a large dry erase board, and it'll look somewhat like a classroom, the room that they're meeting in. And on that dry erase board, they will write out, each team and what their duties are for the day. But before they can erase the information on that board, they actually have someone step up, take a digital photograph of the board, and then that photograph is placed in as part of the evidence in the case. Then they can erase it. And the reason is there have been defense attorneys that have raised the objection in the past that, Your Honor, they erased something that might have been exculpatory toward my client, or in other words, might have helped my client, shown that my client was innocent of these charges, and they erased it, and we can't see it now. So who knows what they erased, or who knows what the officer threw away if you throw away a piece of scratch paper that you took a note on at some point. Once you transferred that note, you didn't need the original, so you tossed it. But an attorney, if they find out about it, can make a definite objection in court that they didn't receive everything, and that perhaps you threw something away that would have shown that his client was innocent. And it's hard, once that item is gone, it's hard to prove that no, there was nothing in there that would have helped your client. But for that reason, we just give them everything. The defense has the right to see and inspect the state's evidence prior to trial. This includes weapons, documents, photographs, scenes of the crime, depending on the nature of the case. To depose a witness is to ask him questions under oath before a court reporter well in advance of trial. In civil cases, depositions are common for all witnesses who may testify. In most but not all states, depositions in criminal cases are rare. Depositions are very rare in criminal cases. I've actually maybe only seen that one time, and it was a situation where a particular witness could not be there on the date. It was almost like a professional witness that had a very important situation. They just simply could not be there for trial. But the defense attorney and the prosecutor actually were able to cross-examine this person on camera on a different day, and then that was played for the jury. So the judge allowed that, but that's very, very rare in a criminal case. In civil cases, they do it all the time. I've actually been deposed in civil cases before, where they call you in, there's a court reporter there, and there's an attorney representing each side, and each side asks you questions, and you simply tell what you heard, saw, or experienced, and they go forward from there. So it's not a terribly painful process. I was a little unnerved the first time I had to go through it, but it ended up being, something that I determined very quickly was not a big deal as far as my part in it. And later I learned just to show up and tell them what happened, and it went forward from there. But you do see that a lot in civil cases. Discovery must be organized both with the prosecutor, who must ensure that all required discovery is given to the defense, and the defense must organize what it receives from the state to better prepare for trial. As far as organizing discovery, we are fairly modern in this jurisdiction as far as the way things proceed. Our cases, once we get our case to the point that it is ready to go up and we don't think there's going to be anything else to add to it, this is around the time the person is charged, maybe just a few days after. We put everything together, we scan it in electronically, and we send it up. There's a special website prepared for this, and it's a secure site that the prosecutor's office maintains, and it runs through the state of North Carolina, and basically everything is submitted electronically. Even though the DA's office was right upstairs from my office when I was a detective, they want it submitted electronically, so we would sit down at our computer and submit it to them. The file goes up, and they hold it there for a time. At some point, and there's under the law, there's a prescribed time when the defense is allowed to get their discovery. When that happens, then the defense attorney is simply given a particular login, and he can go in and log in that packet that law enforcement sent up to the DA's office. There are people with the district attorney's office that maintain this, and they look over the particular time that the defense attorneys get their discovery, and they simply send them the link, and then the defense attorney, or rather usually their secretary or their paralegals, go in and download the packet, and then of course they can print it out, or just give them the computer file, burn it to a disk or a thumb drive or something like that, and the defense attorney can review everything and go forward and start building their defense based upon what the prosecution has. So it's reasonably modern and reasonably up to date. So it's a little better than the old days when you simply had large folders packed with papers. We still have that as the final backup, and a lot of times we'll carry that to court. But as far as the things that go up to the DA's office, those are electronic in general. The largest case I ever had was a large embezzlement case involving, I think, $700,000 that had been embezzled by a secretary and bookkeeper from a certain business. This was a busy real estate office that also built houses and things of that nature. And this went on over a period of 7 or 8 years. And I think my case file was something like maybe 12,000 pages, because it was bank records and business records and tax records on both parties. And anyway, the point is that the cases can get quite large very quickly, many of them. In criminal cases, there's a general rule: the more serious the offense, the more material the government generates. In misdemeanor cases, such as shoplifting or driving under the influence of alcohol, the discovery materials could easily consist of just a few sheets of paper. We don't have discovery in North Carolina in misdemeanor cases. Obviously, a defense attorney can subpoena certain items, but as a general rule, they go into misdemeanor cases fairly blind to the nature of the evidence, and a good attorney will be aware of what typically exists in most cases and will be prepared to run their typical game plan according to what type of case it is. But in felony cases, they do get the discovery. There are a wide variety of discovery rules across the U.S. Some states have not changed their discovery in many, many years. So in some places, a defendant must request discovery. Many states have recognized the discrepancy between civil and criminal discovery and have made changes in their criminal discovery statutes. Many of these new changes require the state to turn over far greater portions of its prosecution and police files to the defense than was ever required before. Again, that's the case here in North Carolina. Typically, the defendant's not allowed to use the discovery process as a fishing expedition. Some information is not discoverable. The prosecuting attorney's mental notes and strategy ideas about the case are not discoverable. They're referred to as the work product. Again, that's the prosecutor's information. As far as law enforcement, they get pretty much everything we've got. However, there are a few officers that will purposely not put tremendous detail into their reports because they claim that their report is in their head and they'll testify about it on the stand and not give the defense attorney an opportunity to know what they're going to say ahead of time. I always believed in writing a thorough report, and basically my testimony was limited to my report for the most part whenever I was on the stand. There might be some minor item that a defense attorney asks about that I failed to put in there that I recall that, oh, yes, I did do that, but unfortunately it's not in my report, but this is what happened, things of that nature. Under the traditional approach, the prosecution's not obligated to provide their witnesses' criminal history, and the defense attorney was left to his or her own investigation to obtain this information. Some states do require the prosecution to provide any criminal records of its witnesses to the defense. A prosecutor is supposed to work for justice, not for convictions, and revealing this information to the defendant will help the defendant prepare his case. Prosecutors also realize that it's better that the jury hear that evidence from them rather than from the defense. I always felt like that I was working for justice too, not that a particular person be prosecuted, but I wanted the truth. When we interview a defendant and we're asking them about a crime, I just want the truth. I don't want to push them into confessing for something they did not do. I wanted the truth, and I want justice to come out on top at the end of the day. But I do not want someone to unfairly be prosecuted. In prosecution offices that follow an open file policy, a defense attorney may review the entire state's file and copy anything useful or helpful. A motion is a request filed with a judge requesting that some action be taken. Defense attorneys routinely file motions, and so do prosecutors. It's very common, and it's not unusual in a large trial to have multiple motions on both sides. The judge will basically rule on those motions and determine whether or not to overrule them or sustain them. Prosecutor motions a lot of times can be similar transactions, aggravation of sentence, or motion to join. In many states, the prosecution is allowed to bring a similar transaction motion so that the jury can hear evidence of the defendant's prior crimes. The state's permitted to present evidence of the prior conviction to show a common method, plan, or scheme by the defendant to carry out certain kinds of crimes. People a lot of times tend to keep repeating any criminal acts that have been very successful for them in the past. They tend to develop the modus operandi, the MO. Basically, they continue to do that. And if they have committed a crime a certain way in the past several times, and this crime is very, very similar, then it would be a similar transaction. A motion in aggravation of sentence is a document that shows that the defendant had a lengthy criminal record or that has a history of violence or harming others. State and federal rules allow a prosecutor to move the court to combine several cases into a single prosecution under specific circumstances. This happens quite commonly. We have certain people that continue to commit crime and maybe have multiple crimes, perhaps over a span of 6 or 8 months, they broke into, say, 7 or 8 different houses and or businesses for that matter. And we were able to put together a case and eventually send that up, indict them. And when it gets ready to go to trial, a lot of times the prosecutor's office will submit a motion to join, and they will join the charges from all that from the 7 or 8 break-ins, instead of having 7 or 8 different trials, they'll have one trial. And, they'll go through and systematically go through each crime and, when it occurred and the evidence required. And they'll go through it step by step until they have everything together. Defendants may raise a wide variety of motions before trial. Regardless of whether a particular state has changed its discovery rules, the U.S. Supreme Court has mandated that certain kinds of information must be turned over to the defendant prior to a trial in all criminal prosecutions. In the Brady versus Maryland decision, the court ruled that when the state has evidence or information tending to show that the defendant is not guilty of the crime, exculpatory information, the state must produce such evidence for the defendant, whether or not the defendant has requested it. When a judge receives a request by a defense attorney under Brady, the judge must conduct an in-camera inspection of the state's file. The state provides the judge with its entire file. The judge goes through it and determines if anything in there may be exculpatory for the defendant. A motion to suppress requests that the judge rule that certain evidence be inadmissible at trial because it was seized in violation of the defendant's constitutional rights. There are multiple other motions. Motion to sever. This is exactly the opposite of the state's motion to join, where you break apart cases and try them separately rather than trying everything together. There's a motion to change venue, where the defense for some reason feels they would have a better chance in another jurisdiction on this particular trial, where it would be more fair. For instance, if there was a particularly brutal murder on someone that was well known, then people in a small county might be upset, and it might be difficult to find a jury of 12 members that haven't heard a lot about the case. Whereas if you went to a different district, you might be able to have the trial where people really didn't know anyone involved and hadn't heard much about it. In Klopfer versus North Carolina, the Supreme Court declared that the right to a speedy trial is as important as any other right guaranteed in the Sixth Amendment, calling it one of the most basic rights preserved by our Constitution. All states have laws that are referred to as speedy trial laws. These statutes allow a defendant to serve on the state a demand that the defendant be tried in this or the next term of court. If the defendant serves a speedy trial demand and is not tried in the specified time, then the charges against the defendant must be dismissed and the defendant released from confinement. While this right is considered one of the fundamental rights guaranteed in the Constitution, defining what exactly constitutes a speedy trial has been difficult to quantify. Each case is considered on its own facts. Although each state has a statute authorizing the filing of a speedy trial, basically it depends on the state how each one of those is worked out. Typically, a delay in bringing the case to trial will help the defendant. So most of the time, they're not after a faster trip to trial. The exception would be if a defense attorney finds out that a particular witness has suddenly decided, I'm not going to testify against the defendant, I'm not going to show up, I'm leaving town tonight. And if a defense attorney found that out, he may actually go ahead and try to get the case before a judge as quickly as possible in order to do that while the particular witness is not around. The right to a speedy trial is triggered when an indictment has been lodged against the defendant. If the defendant files a motion for a continuance, he waives his right to a speedy trial. When the party moves for a continuance, it is requesting that the case be taken off the current calendar and rescheduled for a later date. A motion in limine requests a ruling on the use of a particular piece of evidence or a limitation on the kind of testimony that a witness may give on the stand. When a defense attorney suspects that a prosecution witness has been offered a deal for his testimony at trial, she can file a motion requesting the details of the arrangement. Defense attorneys may file a motion to reveal the identity of a confidential informant who was involved in the case. Police and prosecutors protect their confidential informants because to release their names to the defendant might put the CI in danger of being killed. I've seen this multiple times, and a lot of times there are motions where they want that identity revealed in court, but the courts have been pretty good at standing up and saying, no, this person, we're not going to reveal their information directly because it would put their life in danger. Okay, that's the end of that particular presentation. Thank you, and have a great day.